완전아, 예, 말씀하십시오. 완전아, 우리가 강요 한 잔, 지금까지 없었던 비슷한 시간만을 너무 서장을 발행할 수 있습니다. 이제 우리 조선은 정말 혁명적인 변화를 겨나고 있습니다. 그것은 멋지다. 함께하는 사람들이 우리를 위해 칭찬하고 싶다. 그런데 우리 덜자고 동방을 다녀오겠다. 이 변화를 외국 정치 받아주지 않을 것인지 그게 내가 거짓이었는지 걱정됩니다. 왕정아, 우리가 이 기술을 가려가는 것의 가장 좋은 방법입니다. 그러나 우리나라에서 토질 있고 외국인들이 우리가 개발한 것을 별수다 하면 우리 기억에서 새로운 발명이 죽여질 것입니다. 정말 큰 문제이다. 우리 기술을 받기 전에 그렇게 되어야 한다. 이 시간들은 우리 중요해야 할 것이다. 가장 신비한 형목이 이 것이다. 우리가 분직하면 혈벽이 체경을 비출할 수 있다. The designs from our looms are being sold in the London markets.
Impossible. These are my original weaving patterns. Nobody else has access to them.
But they do. All our designs are being stolen, and I also heard that the French were copying our designs and selling them overseas. Without protection for our designs and our copyright, innovation will go waste.
This is outrageous. We spent years developing these new techniques, and somebody just steals them from us. We need copyright laws to protect creators like us.
But what can we do? There are no copyright laws.
We must lobby the parliament, because without protection of our intellectual property, innovation will die, and so will our economy with it. From the east to the west, no copyright has certainly caused a lot of problems across time. And that's why we have a very important evolution of copyright to study. So let us look at how it has evolved over time, from the quill to the click. The concept of copyright, as we understand it today, might seem like a modern invention, but it roots back to centuries. In ancient and medieval times, the focus was not on individual creators' rights, but rather on controlling the spread of knowledge and ideas. Scribes in monasteries, often the sole custodians of written works, held considerable sway over the copying and distribution of manuscripts. The invention of the printing press in the 15th century dramatically transformed the landscape of information dissemination. Suddenly, replicating text became significantly easier and more economical. This innovation challenged the existing control over knowledge and paved the way for a more formalized system of protecting creative works. The printing press, a revolutionary invention by Johannes Gutenberg, had a profound impact on the development of copyright law. Before Gutenberg's invention, the laborious work of hand copying the manuscripts limited the potential for widespread reproduction and distribution of literary works. The printing press, however, enabled the mass production of books, pamphlets, and other printed materials. In England, the Stationers' Company, which was started in 1557, was a guild of printers, and it played a pivotal role in shaping early copyright law. Because the Stationers' Company was granted monopoly over printing and publishing, allowing them to control which works were reproduced and which was disseminated. This system, while it benefited the members of the stationers' company, often stifled the competition and limited the availability of other works. The 18th century witnessed the birth of modern copyright law then, because in 1710, England enacted the Statute of Anne, a landmark piece of legislation that shifted the focus of copyright protection from the printer to the author. The Statute of Anne granted authors exclusive rights to their works for a limited duration, after which the works would enter the public domain and they would become free for anyone to use and adapt. Across the Atlantic, the newly formed United States followed suit with its own Copyright Act in the 1790. This act, which was inspired by the Statute of Anne, similarly aimed to promote the progress of learning and the useful arts for securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. The Berne Convention flourished as international trade and cultural exchange came into being in the early 19th century because there was a need for a harmonized system of international copyright protection because it was just increasingly apparent. So the Berne Convention for the Protection of Literary and Artistic Works, which was signed in 1866, emerged as a pivotal step in this direction because it established a framework for reciprocal copyright protection amongst member countries. It also introduced the principle of national treatment, which meant that member countries should extend the same copyright protection to foreign creators as they would do to their own citizens. This helped prevent any kind of discrimination that might happen during the exchange of creative content across a global scale. And then, the late 20th and early 21st centuries witnessed an unprecedented technological revolution because there came personal computers, the internet, digital media, and this digital revolution profoundly impacted copyright law because it posed various new challenges and opportunities for creators, copyright holders, and consumers. The ease with which digital content could be copied, shared, and distributed online strained the traditional notions of copyright protection. And it was a new challenge to be addressed. So in the United States, the Digital Millennium Copyright Act, or DMCA, was implemented along with treaties of the World Intellectual Property Organization, that is the WIPO. So the DMCA criminalized the production and dissemination of technology, devices, or services invented to circumvent measures that control access to copyright works as digital rights management, or the DMCA also addressed the liberty of online service providers for copyright infringement by their users, and hence it provided a safe harbor for platforms that meet certain conditions. And hence we see the importance that copyright law has had as the times have evolved. So from the quill to the click, copyright law is still evolving to this day and still holds a lot of importance for the world of creativity.